I just thought I'd start by saying, for some of you who were here last year, I actually already gave a talk at last year's seminar on discrimination, and I just wanted to run through at least a very canned introduction to that topic, because some of the things that I'll say follow on from things that I talked about last year, but I don't want to have any kind of assumed knowledge. What I covered last year was to speak a little bit about the phenomenon of rational discrimination on various demographic grounds like race, age, sex and things like this. And I talked about the fact that certain kinds of discrimination based on those characteristics often arise as a rational response to limited information about individuals. And particularly in contexts where people have to make decisions about individuals who they've either just met or know very little about. Although it is obviously rational to assess people by their individual merits, quite often those individual merits for whatever particular application are not known. And statistical science essentially tells us that when that's the case, you can try to guess those things by taking any characteristic of the person that is known, which is correlated with that, and using it as a kind of a proxy to guess things. And it does turn out to be the case empirically that a lot of these demographic characteristics like race, age, sex are correlated with various individual merits of various different kinds in various contexts. And so quite often in those situations of limited information, you get this phenomenon of rational discrimination arising, where, say, sex discrimination or race discrimination does occur, but in my view it's quite justifiable, quite logically valid that it does occur, and I also argued last year that this was morally legitimate kind of discrimination. So this year I want to talk about a particular application of that idea where things get a little bit more complicated by some other considerations, and that's talking about discrimination in the context of law enforcement. And this runs into certain philosophic ideas we have about the law, and in particular about equality before the law. The question of discrimination and demographic discrimination in law enforcement follows the same kinds of principles as what I've talked about previously at this seminar, but there are new additional considerations that come up that are quite interesting. Another reason that I did want to talk today about discrimination and equality before the law and talk about discrimination in the context of law enforcement is, I think quite often, I've written a few articles and given a few talks about rational discrimination, making the point that various kinds of sex discrimination or race discrimination can be perfectly valid. But it's also the case that many of the groups adversely affected by discrimination do have a legitimate complaint of some kind and are being unfairly treated in some way. And I think there are sometimes cases where discrimination per se gets the blame for a different problem which is not identified. That probably won't really make sense now, but it'll become clearer as I go through my talk. So that's part of the motivation for speaking about this topic today. So I just wanted to start off talking about something called demographic profiling, or it's sometimes called race profiling or sex profiling if we're talking about a specific characteristic, or just profiling in general. And demographic profiling is essentially what happens when a police officer or any other enforcement agent uses demographic characteristics such as sex, race, age, things like this, as factors to inform their decisions about the detection of lawbreaking or the enforcement of sanctions in lawbreaking. So if, for example, a police officer targets a suspect because of their race for whatever reason, that would be an example of race profiling, or more generally of demographic profiling. Now, obviously, rational discrimination can occur in this context just as in any other. And it tends to arise most commonly simply because, as with other areas of human activity, various groups are more or less likely, simply as an empirical matter, to take various actions that are prohibited by the state, whether those are legitimate prohibitions or not. And so long as there's any kind of disparity empirically between demographic groups in terms of the actions they take, that means that there arise various high-yield groups and low-yield groups for if you're looking around for, well, what kind of group might commit what kind of action. And demographic profiling does arise in this circumstance. So there's two aspects to this when you're talking about law enforcement that I think it's important to consider separately, to the extent that they can be well separated. One is to talk about the use of demographic discrimination in the detection of law breaking. And this is where, say, a policeman or another enforcement agent might use demographic characteristics to try to inform their guess as to who has or hasn't broken a particular law. There's also then the separate question, once they feel that they have identified a potential lawbreaker and that they have the evidence to demonstrate that, of whether or not demographic characteristics are used as a factor in deciding on what the appropriate sanction is for lawbreaking. Now, this becomes very important when we talk about the principle of equality before the law. And broadly speaking, the principle of equality before the law simply says that the same law should apply to everybody, that there shouldn't be different laws for different race groups, different laws for different sex groups, different laws for different age groups, discounting, of course, the distinction between children and adults. And so if we agree with this principle of equality before the law, and I think libertarians do that, there is obviously a danger if distinctions are being made on these kinds of grounds, sex, race, age, etc., that this may violate that principle. And the reason that I demarcate these two categories is that I think one of these, we find that rational discrimination can occur and be quite legitimate, and that's in the detection of lawbreaking. That quite often the police encounter situations where they have a high yield and a low yield group for a particular investigation, and they'll tend to target high yield groups. If we find the use of demographic characteristics being used for enforcement decisions, that's, I think, where we start to run into troubles with saying, well, now we no longer really have equality before the law if a particular demographic group is being given a different kind of sanction for the same act as another kind of demographic group. So I break this kind of law enforcement structure down into these two areas. It does become a little fuzzy in the middle in some cases, and that can be difficult, but I think they can be broadly demarcated, and we can see that that second category of the enforcement of sanctions can give rise to problems with equality before the law if discrimination intrudes into that ground. So I'll just give you a bit more of a concrete-based example of demographic profiling. I want you to imagine that you're a police officer, and I'm going to also ask you to imagine for a moment that you're not a libertarian, and let's set aside any objection we have to the idea that, say, marijuana, the possession of marijuana is illegal. Let's set aside that objection in our minds for a moment, and just think about the enforcement of that law. And I want you to ask you, who's carrying weed? Who is more likely to be carrying weed? Okay? Now, I pulled these pictures at random off the internet. I'm presuming probably none of you know either of these two people. So in one sense, the answer is you have no idea. You don't know either of those people. You don't know anything about them other than what you can glean from looking at those two pictures. And yet I suspect, from the laughter if nothing else, that probably some of you have immediately formed a confident impression of which person you think would be the higher yield candidate for a random search, say. All right. Now, we could prohibit other things than weed, and let's suppose that we decided to prohibit Spider-Man comic books. So I ask again, who is more likely to be carrying a Spider-Man comic book? You're a police officer going around patting people down for their prohibited Spider-Man comic books. Who is the more high-yield candidate? I think for any of you who have ever been to a comic convention, say, you'll know that the candidate on the left is a mythical creature, virtually, at a comic book convention, unless she's perhaps an actress in a sci-fi series and she's paid to be there. So I think in that context, we can form an impression of who might be the more high-yield candidate. And we can do this again if we were to prohibit, say, the carrying of fountain pens, and we can ask who is the more high-yield candidate for a fountain pen. Now, with all of these examples, and I'll just go back through all of them, I've actually been a little bit sneaky because this isn't purely demographic discrimination that's occurring. And in fact, I suspect that a large part of that distinction is formed on the basis of things like personal grooming, choice of clothing and things of that nature. And I think in all three of those examples that's quite a large part. The particular clothing of these two people is a big factor in that case. Probably also in the last case we've got the distinction between a business suit and a baseball t-shirt. And yeah, I think there's probably a high correlation between Hawaiian shirts and the carrying of comic books also. So in all three of those cases, this isn't purely demographic discrimination, but nothing ever really is. It's never really quite that clean cut. In reality, what we tend to do is take the totality of the impression we get from the looks of a person, and that includes those demographic characteristics, but it's not limited to those demographic characteristics. And we get from that an impression, just from our knowledge of society, of empirically what kind of people do what kind of actions and what do they look like, we get that kind of impression. And the conclusion from these three examples is fairly clear, which is unfortunately that you're all a group of inveterate bigots. And I'm sorry to have to be the one to break that to you. But in seriousness, there is a rational basis behind any of those three cases of discrimination. In those three cases, it's probably, for effect, I've used a large difference in clothing and grooming as part of the example, but also other factors may come into it, and other factors, including demographic factors, may come into those decisions. So these are the kinds of phenomena that can arise in law enforcement as well as in other contexts. Now, I've said that there's a demarcation that I think is important between discrimination in the detection of crime and discrimination in the enforcement of crime. Discrimination in the detection of crime can, in many cases, be rational, including demographic discrimination, for the simple reason that various demographic groups are more or less likely to take some prohibited action, depending on what that particular action is, than other demographic groups. And police are aware of this, as are all other human beings. Discrimination in enforcement is much more problematic, and I would argue that it tends to be irrational to engage in demographic discrimination in choices of enforcement once you have identified a lawbreaker. Because if you're doing that, you're then holding people to a different standard of law. You're saying the same action committed by two different people is of different severity according to characteristics that are not chosen by them. So going back to one of our examples here, if you're like myself, you'll have concluded that the gentleman on the right is probably more likely to be carrying weed, but if she has weed, it's the same act. And therefore, if we wish to apply discrimination rationally, without falling into this trap of breaching the principle of equality before the law, we may very well focus our investigative attentions on this gentleman, if we believe that he's more likely to be carrying weed. If for whatever reason our investigation turns up that this lady has weed, then we would need to be careful to make sure that we hold her to the same legal standard as this other gentleman. And remember, again, I'm setting aside here any objection to the underlying law, just for the moment. So the principle of equality before the law tells us that even if this guy here is more likely to be carrying weed, if this lady here is actually carrying weed, she should be held to the same enforcement sanctions and the same rules of law as this other gentleman, notwithstanding the fact that she's in a different demographic group. Now, I said at the start of the talk that I think sometimes there are situations where a group is targeted or discriminated against adversely in a law enforcement context where I think they do have a legitimate underlying complaint, and I have a lot of sympathy for many of these situations. I think sometimes we misidentify the problem as discrimination, when in fact sometimes the problem is something deeper. And to demonstrate this, I wanted to look at a particularly common pattern I see in law enforcement, in our kind of legal structure that we have now. Our legal system for enforcement involves a state territorial monopoly, and that state prohibits many things that are victimless crimes. And one consequence of this is that there is no clear complainant for this kind of behaviour. If we look at, say, the prohibition of marijuana, there is no clear complainant that would be the victim of that act that ought to have standing to prosecute and seek enforcement against a, quote, wrongdoer who's carrying marijuana. Now, partly as a result of this fact, but partly more generally as a result of the state's monopoly on law enforcement, the state, rather than viewing crimes as crimes against individuals, views them as crimes against society in such a case where it has a trustee role for society, and therefore they're essentially crimes against the state. So if you're familiar with how law enforcement works, you'll know that if you're a victim of crime, you're not the person that takes the wrongdoer to court. It's a state prosecutor that takes the wrongdoer to court, and the court case isn't between that alleged wrongdoer and the victim, it's between that alleged wrongdoer and the Crown. And so you get the case of Higgs versus the Crown, or Joe Smith versus the Crown. Okay? So the state takes on this role of the victim, or at least the representative of the victim being society in some abstract sense. And this means that the government authorities, through their various branches, have full control over the enforcement of sanctions, unlike in a case where, say, the victim is the one that decides whether or not to pursue particular sanctions. Now, that role is split up. It's split up partly between the police and the prosecuting attorneys, who have quite a bit of control over the enforcement of sanctions through their capacity to use their discretions in what kind of charges they'll seek, what kind of plea bargains they'll seek, and so on. And then beyond them, there's the judicial branch of the government that decides on the sanctions if there's no bargain reached between the executive side or if the person, say, pleads not guilty. But all of these mechanisms occur within the state, just within various branches of the state. So this means that initially already we have a situation where, rather than the victim having control over enforcement and being able to use whatever criteria they believe are appropriate, we have this monopoly agency that has control over the enforcement of sanctions for crimes, including what are really non-crimes. But we'll set aside that objection and call them crimes for the moment. So I want to talk about a pattern that sometimes arises in this context. There is something bad happens, and we see on the news that, say, a man was beaten up in his car, and therefore the police need much wider powers to deal with this epidemic of a man being beaten up in his car. And it never really occurs to people that, well, perhaps that was already illegal. So, sure, we need wide new police powers, they need stronger search powers, they need stronger enforcement powers, and so on. So let's imagine then that the state imposes some wider police power. And when I say a wider police power, I mean they give the police more authority to do the kinds of things that would involve aggression against people if it was done by anyone else. Say, stopping you in the street and searching you, or giving you a strip search when you don't want to do that, or something of this nature. So the police get some new wide power. If we look at now the position of government agents who are going to be using that power, they operate under a certain kind of incentive structure. The agents of the enforcement authority are incentivised to use that power to obtain arrests and convictions. And I'm usually talking about police here, but there are also bureaucratic agents that have enforcement powers over various laws, but I'll mostly talk about police. So the police want to obtain arrests and convictions, and they want to obtain outcomes which look good from their personal point of view as a police officer, look good to their employer, look like they're doing their job well, and they want to get their stats up. So if any of you guys have ever seen the TV series The Wire, and all of the police are duking the stats, meaning they're all trying to make the department stats look good, and they're trying to get their personal stats up. So this is their personal incentive, or at least part of their personal incentive in their job, is to obtain lots of arrests and convictions. Beyond this, because they work in an agency which has this monopoly over law enforcement and which heavily insulates its own agents from any kind of liability for incorrect judgments, they pay essentially no penalty for getting things wrong. There might be a slight career penalty in some circumstances, and we'll talk about that later, but the police in general can violate people's rights, and they are generally not prosecuted for it, except perhaps in very extreme cases. So the police aren't terribly concerned, or not as concerned as they would be, about false positives, false cases where they think someone's committing a crime and they use whatever powers they can to detect that, but it turns out not to be the case. What they are interested in is two things: targeting groups that are high-yield groups to get arrests and convictions, and avoiding antagonising groups that are able to mount effective complaints and political pressure on their own jobs. And there's an interrelation between these two things. And those two things, by the way, can be different groups, and that also can exist to an extent overlapping in the same group, in which case they're weighing off two different factors in their decisions. And on the basis of these two kinds of things that they're trying to do, they will have incentives to discriminate by race, sex, age, etc. And if we take this back to those two things, we can see why. One is that they want to target high-yield groups. So they want to go back to all of these people that I showed before, and out of each of these cases, say if they're prohibiting Spider-Man comics, they want to target this guy on the right because he's in a high-yield group. So they're going to race discriminate, sex discriminate, age discriminate, Hawaiian shirt discriminate, and so on. And that then gives them a high-yield group. Simultaneously, they also want to avoid groups that can mount effective pressure against them, and that tends to be high socioeconomic groups, but not always. It can also be low socioeconomic groups that are well represented politically, and depending on the particular context, the police will have some sense of groups that might be antagonised and be able to put pressure back on them. So simply for the sake of their own jobs, they have these certain incentives to discriminate in favour of particular groups, away from particular groups, just for personal security in trying to advance their own careers. So that's the position of government agents. So let's suppose that on that basis they decide to target generally high-yield race, sex, age groups, and this leads to discrimination or demographic profiling, if you wish to call it that. And so, for example, they might pick a particular demographic group and say, you, maybe not explicitly, maybe just implicitly think you are the most likely to be carrying Spider-Man comics, so we're going to pat down anyone that looks like this looking for Spider-Man comics or weed or fountain pens or whatever. What happens next? The targeted group notices that they're being discriminated against in an adverse capacity, and things are being done to them they don't like, and they complain that they are being profiled and that this is a breach of their civil rights and that this is contrary to the idea of equality before the law. Okay? Now, what frequently happens is that instead of challenging the underlying powers of the police or the underlying structural incentives, the complaint is about the discrimination. And so discrimination is then raised as the issue, that the problem is police discrimination. And to solve the problem, well, if the problem is discrimination, obviously the solution is to avoid the discrimination. And hence the solution is to continue to apply the wide abusive powers, but now apply them indiscriminately, meaning more widely. And this is quite a common pattern you'll see in law enforcement. So this creates a big problem. Okay? We have a situation where discrimination, despite the fact that there are often very rational causes, is getting the blame for underlying structural problems which may be the real cause. And one of the difficulties is that those underlying structural problems are much more difficult for people to see. The immediate effects of discrimination are much more obvious. So how the problem is solved? The enforcement authority eventually caves into political pressure, continues to want to have their highly excessive powers, but simply decides to apply them more indiscriminately to avoid the charge that they're race discriminating or sex discriminating or age discrimination or whatever it is. The population at large now become more subject to police power. Probably the initial targeted groups are still only subject to the police power to the same extent as before, or perhaps even a little less if they're diffusing it a bit more, that's possible. But the population at large are now more highly exposed to that wider police power, and therefore they tend to become inured to this. And beyond that, how can they really complain? If they didn't complain before when they weren't the targets, and they complain now, what are they? It starts with R. Racists. Or something else. Sexists, whatever. So this is a very common pattern, that a wide new power is implemented. For various incentive-based reasons, that power is directed mostly at high-yield groups. Eventually, political pressure is brought to bear on the enforcement agencies that this is unliked. People don't generally have a good understanding of rational discrimination, so they tend to believe that this is the true cause of the problem. And therefore, since no one complained about the wide police power in the first place and thought that was a good idea, and they're now complaining that discrimination is occurring, it only makes sense that everyone should now become subject to widespread abusive power, because that then is fair. And so, one other effect of this is that now that the detection method is applied more indiscriminately, it loses that predictive power it had before. The police are now no longer targeting most commonly high-yield groups. And therefore, the power itself becomes less effective. Because in actual fact, there was a rational statistical reason why that was occurring. That led to more arrests, more convictions, more instances where they were finding pot, more instances where they were successfully finding Spider-Man comics, and so on. And so now they have this wide power, but now their capacity to enforce the law is going down. And of course, what happens when the police lack the capacity to effectively enforce the law? They need more power. And so we have a kind of a cyclical situation. So I've just put that up in a little bit of a cycle diagram just to summarise what I think sometimes happens in these cases. We have at the top the introduction of broad new powers. This then creates incentives for government agents, and those incentives lead to the targeting of high-yield groups, i.e. discrimination, often on demographic grounds and other grounds. This leads to a complaint of unequal treatment, and as a result of that complaint, once it gets sufficient momentum, the police or whatever investigating authority then begin applying their powers less discriminately, more indiscriminately, therefore more widely, to solve that problem and take that pressure off them. As a result of the now indiscriminate application, the enforcement is no longer as effective. And now that we have ineffective enforcement, we have, of course, back to the top, the call for broad new powers. And this is kind of a nice little bicycle ride into totalitarianism. Maybe it takes 2 or 3 iterations of this, I don't know, it'll depend on the context. But it's a nice little cyclical way of gradually expanding the powers, both in terms of the actual authority of the police and the breadth of the application to the population. Of course, discrimination gets the blame for all of this, rather than those kinds of underlying incentive-based factors and structural factors I've talked about. And in fact, it's common to see people complain about these policies, saying with them, the problem is discrimination. The police are racial profiling, the police are sex profiling, the police are doing whatever. Or maybe it's not the police, maybe it's some other enforcement agency. And the nasty part about this is that the only rational part of that system, or at least one of the only rational parts of that system, which was the rational discrimination in terms of the identification of people taking various actions, gets the blame for an underlying bad system. Because many of the underlying structural ideas of the government monopoly and the incentive that creates for its agents are not well understood and are virtually invisible to people. They imagine that there's no real other way that law enforcement could be done. Now, this kind of situation tends to arise most commonly in the contexts of prohibition laws, prohibitions on the possession of various kinds of goods, and other laws which don't have a victim and therefore don't have an obvious complainant. Simply because in those cases, with lacking an obvious complainant, the state is the complainant, and therefore it makes sense that the state would have full discretion over enforcement and so on. Another reason that discrimination occurs more widely in these cases is that there is often less direct evidence of wrongdoing in those cases. When you're talking about cases of, say, rape or murder, there's usually much more direct evidence in those kinds of cases, maybe a bloody butcher's knife or a jealous husband or whatever it is. And so police don't need to rely, and indeed can't really rationally rely, on demographic characteristics once they have quite a bit of direct information. What tends to be the case, this was something that I covered last year, but I'll just mention again, what tends to be the case with rational discrimination is that these kinds of proxy characteristics used to predict high-yield groups are mostly informative when you don't know very much about people at all. So, for example, when I put the sets of faces up, you knew nothing about those people other than just seeing them right then. But if I started telling you more and more about the properties of those individual people, their demographic characteristics would start to become less and less relevant and less informative because you would have more direct knowledge. And so therefore the direct knowledge would be taking over and those proxy characteristics would fade into irrelevance. And that tends to be what happens in rational discrimination cases. And therefore when you have very serious victim-based crimes, as in actual crimes, and there tends to be direct evidence, race, sex, things like this tend to become irrelevant. Unless, of course, we're talking about something like rape where sex is directly a necessary criterion for who you're looking for, say. So this means that actually, although many statists complain about discrimination in these cases, quite often the reason discrimination is so common as it is because the nature of the offences being made, or the nature of the things being deemed offences, are victimless minor things in which there's often not a lot of direct evidence to look for a suspect, and therefore it's rational for police just to go down and pick people out based on demographic characteristics and look through high-yield groups. So this tends to occur quite commonly in those situations. And this means that discrimination will tend to be most effective and most widely practiced in those situations. When the law relates to some action which is non-violent and therefore not easily detected and with no obvious complainant, when there's a large differential in the relevant action among different demographic groups, and when the requirements for searches and enforcements are broad and don't require specific evidence, meaning that there's not really any penalty for false positives and there's not really anything stopping police just harvesting through high-yield groups. So I wanted to look at a couple of examples of this. Actually, before I do, I'll just ask for a time reminder. 2 minutes, okay. In that case, I will just go through one example. All right. Well, look, I might skip my first example, which was going to be the TSA, but I'll talk about the NYPD and the Stop and Frisk program. So in New York, the police have fairly wide powers to stop and frisk suspects. The actual legal requirements do require them to have some reasonable suspicion, but the way these powers have tended to be practiced, particularly over the last 10 years, many of the searches and stops have been quite dubious in terms of their legal justification. And this has been becoming more and more of a controversial issue in New York over the last 10 years. Mostly actually owing not so much to the introduction of new broad powers, but the ramping up of the use of an existing power. From about 2003 to 2013, there's been quite a ramping up within New York, based on the stop and frisk statistics, of the number of people stopped and searched by police, often on quite dubious pretexts. So although we don't have quite an introduction of broad new powers, we do have the ramping up of an existing power. And the goal of this, according to the police department, is to prevent the illegal carrying of firearms and other prohibited goods. Okay? And there's not a great deal of success, of evidence of success of this program, at least with respect to firearms. With respect to contraband goods, it's a little bit more successful, if indeed you regard the successful prohibition of contraband goods as a success. So the incentive for government agents in this particular case is fairly clear, and it's as I've been talking about. The police need to get their arrest statistics up, and in fact, even beyond this, within New York, stop and frisk searches are actually a direct police statistic that are used as evidence of positive performance. So the police have both a direct incentive to engage in stops and frisks and an indirect incentive in terms of trying to find arrests and convictions to get their stats up. So they're incentivised to target high-yield groups, and within New York City that means essentially mostly targeting young black men, to a lesser extent young Hispanic men, to a lesser extent again young white men, and then beyond young men to a lesser extent other demographic groups. But mostly the high-yield targets have been young black men, and indeed if you look through the statistics on stop and frisk, you'll see that a very large number of young black men have been stopped and frisked under these powers, much more than according to their proportion in the population. Okay, so the police are targeting this group because they believe they're a high-yield group. They know they're more likely to find something and get an arrest and a conviction if they target a group that they know is more likely to be one engaging in that action. So stop and frisks have been applied mostly to young black men, and then more widely, I suppose, to young men in general. And this has led to complaints of unequal treatment, most particularly along the lines of race. Most particularly, there's been complaints that this is racial profiling, which it certainly is. And over the 10 years that this has been ramping up, obviously as the number of these things has gotten larger and larger and the abuses have gotten more and more, the pressure on the police department over this has been increasing, that there have been more and more accusations of racism against the police department. And as a result of that, we've got a lot of kind of protest rallies. Here's a gentleman at a protest rally holding up a sign. It says, "They never stop and frisk old white guys like me," which is probably mostly correct. He's in a low-yield group. But it's interesting, his complaint. It's a very interesting complaint to make. Because really the problem here is that police are stopping and frisking people without any real evidence to support their suspicion, on very dubious grounds. And certainly they're targeting one group more heavily than another. But is the problem really that they don't stop and frisk old white men? Would that fix things? I mean, if this guy started getting frisked a lot, would that make him happy? Would that end the problem? And so this is a perfect example of the fact that discrimination ends up taking the blame for a deeper problem, and a problem arising from an incentive structure that's unexamined. And the solution put forward by, well, not explicitly by this gentleman, but implicitly, is that if only the police would take this abusive power and apply it more widely, that would be fair. Right? And again, I say this is a little bit of a bicycle ride into totalitarianism. You've got presently expansive abusive powers being unfairly, well, in one sense unfairly directed at a particular group, unfairly in the sense that the power shouldn't exist in the first place. Given that the power exists, there's a perfectly rational reason why it's directed there, because they're a high-yield group. And so this is the kind of mentality, I suppose, that I wanted to talk about today and wanted to warn against. So I suppose just in summarising, I was going to talk about the libertarian solution, but I think that's fairly obvious. I think in summarising, I would simply say that cases like this, you quite often see that rational discrimination takes the blame for a deeper underlying problem, which is not well understood. And as a defender, I suppose, of discrimination in general, since I'm a statistician, discrimination is my bread and butter, this offends me. And I do also worry at the implications of saying that things are made okay if we take abusive state powers and make sure they're applied more broadly. And I'll just leave you finally with the implication of this, which is TSA men patting down little disabled boys at airports. So thank you very much.